Welcome to the law offices of Chris M. Ingram's Immigration News. Today we're going to cover a topic that we have had a lot of requests to cover, and that is the topic of retrogression in U.S. immigration green card applications. For those going through any green card application, if your application is subject to retrogression, you could be waiting years for your green card to come through. So let's find out what this is all about, and we'll show you how to navigate it successfully. We want to thank attorney Chris M. Ingram and his staff at the law offices of Chris M. Ingram, who have worked very hard in researching and preparing the legal research for this show. Please also note that this show should not be regarded as providing legal advice to your particular situation. However, if you would like a free consultation, please go to our website at www.breakthroughusa.com. We'd love to help you, if we can. We'd also encourage you to visit our various platforms on Spotify, Facebook, YouTube, X, LinkedIn, and Instagram, as we are growing a fantastic community there.
All right, let's unpack this term. Retrogression. It just sounds like a step backward, doesn't it?
It really does, yeah.
And for many incredibly talented professionals dreaming of building a permanent life here in the U.S., it can feel exactly that way. It's like that moment when your carefully laid plans just hit this unexpected and often incredibly long pause button.
A really long pause.
But our mission today is to give you a clear roadmap. We want to turn this complex, often, disheartening concept into actionable knowledge so you can keep moving forward, maybe accelerate your journey, and secure your future.
Absolutely.
We're talking about how to avoid potentially decade-long delays and really unlock your potential here in the U.S.
And what's truly fascinating about retrogression is how this single concept can dramatically impact not just an individual's career path, but their entire family plans, too. It's a systemic issue, really, that often catches people completely off guard.
Yep.
So today, we're going to dive deep into why this happens, kind of peeling back the layers of immigration law and the stark realities of, demand versus supply. We'll explore who it affects most, often, brilliant individuals from specific countries, and critically, how you can strategize to maybe bypass these delays, effectively turning a potential roadblock into a strategic detour on your path to permanent residency.
That sounds hopeful.
Yeah, and this raises an important question right from the start. If you find yourself on what looks like a long, uncertain path, what proactive steps can you actually take to accelerate your journey?
That's the key question, isn't it? And to truly grasp the gravity and, like you said, the personal implications of retrogression, we first need to set the scene a bit. We need to understand the typical immigration journey for many international professionals, particularly those in critical STEM fields. It's often a carefully constructed path, starting with a temporary stay, like a bridge to a longer-term dream.
Right, that initial phase.
Exactly. This initial phase, while it's not permanent, lays the essential groundwork for their U.S. careers and, hopefully, their future green card aspirations. Let's begin by tracing this path, starting with what often serves as the entry point for many aspiring professionals: the F-1 student visa.
Okay.
So the F-1 visa is pretty straightforward in its main goal, right? It lets international students come here for some-time academic programs at accredited U.S. institutions. Think of it as your academic passport, opening doors to world-class education and specialized skills.
A really important first step.
Absolutely. But it's crucial to remember its non-immigrant nature. This visa is explicitly temporary. It's tied to your studies, and it's not a direct path to permanent residency.
That's a key distinction. Not permanent.
Not permanent at all. Yet, its significance, it cannot be overstated. For countless aspiring professionals, especially those from countries like India, the F-1 visa is the foundational first step. It opens doors to advanced degrees, crucial skills development, and later invaluable practical experience right here in the U.S. It's truly where dreams of a U.S. career often take root.
It's absolutely foundational. Without that initial academic immersion, getting those specialized degrees and expertise, the subsequent steps we're about to discuss just wouldn't be possible.
Makes sense.
And this investment in their education, it benefits both the individual by enhancing their skill set and, frankly, the U.S. economy by bringing in top talent. What our researchers at the law offices of Chris M. Ingram often see is how this initial F-1 period is just a vital time for students to start building their professional network and really understanding the U.S. job market.
Yeah.
That becomes crucial later on.
Exactly. And once that education is complete, academic knowledge needs real-world application, right? That's where something called optional practical training, or OPT, becomes absolutely critical for many.
OPT, yeah, very important.
So what exactly is OPT? Well, it's a program that permits F1 students to work directly in their field of study, applying what they've learned in the classroom to a professional setting. This can be done either during their studies, that's pre-completion OPT, or more commonly after graduation, which is post-completion OPT.
Right. Post-completion is what most people use.
Yeah, typically. And the standard duration for that post-completion OPT is up to 12 months. But here's where the STEM advantage truly kicks in, and it's a real game changer.
The STEM extension.
Exactly. For graduates in science, technology, engineering, and mathematics fields, there's an additional 24-month extension. This means STEM graduates can accumulate a total of 36 months. That's 3 full years of practical work experience.
That's 3 years. That's significant. It's huge.
Yeah.
This extended period is incredibly important for students, particularly those from India, because it provides a much longer window to gain hands-on experience, demonstrate their skills to potential employers, and hopefully secure the jobs that will then allow them to transition to longer-term employment. It's often where the real-world application of their studies truly begins, transforming academic knowledge into valuable professional experience and really preparing them for that next big step.
The STEM OPT extension is indeed vital, and, especially for the U.S. economy, too. It lets these highly skilled graduates contribute significantly to American industries right after their study.
Good point.
Chris M. Ingram's team observes that this extended practical experience, well, it not only benefits the individual in building their resume and network, but also provides U.S. companies with access to a really crucial talent pool. It's kind of a win-win scenario, preparing them for what's often the next critical stage of their immigration journey, the H-1B visa. And that next stage is often where the rubber meets the road for many, the H-1B work authorization, which bridges them into those specialty occupations.
The famous H-1B.
Right. The H-1B visa's purpose is to allow U.S. employers to temporarily employ foreign workers in specialty occupations. These are roles that typically require, say, a bachelor's degree or its equivalent in a specialized field, often STEM-related.
Specialized knowledge needed.
But getting an H-1B is frequently a high-stakes game, isn't it? There's that annual cap of 65,000 visas, plus an extra 20,000 specifically reserved for those holding a U.S. master's degree or higher.
The master's cap, yeah.
And due to consistently high demand, particularly from countries like India, this program often operates via a lottery system. That makes it incredibly competitive and, frankly, quite stressful for applicants.
Oh, definitely stressful. That lottery is unpredictable.
So why is India's role so significant here? Well, attorney Chris M. Ingram and our researchers highlight that India produces this massive pool of STEM talent. We're talking engineers, software developers, researchers who consistently fill critical gaps in U.S. industries like tech and biotech.
Huge talent pool.
It's enormous. In fact, our studies show that Indians account for a really significant portion of H-1B approvals, often extending their stay for up to 6 years, 3 initial years, plus 3 more. This really underscores the immense STEM talent from India that is not just present, but actively filling crucial roles in U.S. industries.
The H-1B is often the first sort of long-term temporary status for many of these professionals. It acknowledges their specialized knowledge and the clear demand for their skills in the U.S. economy.
Right.
However, as our legal team points out, the lottery system itself introduces this level of uncertainty that can be quite stressful, even for highly qualified individuals. It's really a testament to the talent pool that, despite these hurdles, so many are successful in securing these visas and making invaluable contributions. But here's where Chris M. Ingram's insight truly becomes vital.
That's a great segue because it brings us back to a really critical insight that attorney Chris M. Ingram often shares. He says, the F1 to H-1B bridge is like crossing a river to reach fertile land. It's essential, but the real harvest comes with permanent residency. Don't let temporary status define your future. Plan for the green card from day one.
That's such a good quote. Really hits home.
It's a powerful statement. But, why do so many talented professionals, despite their intelligence and foresight, often miss this critical early planning? What's the biggest mistake they make by focusing only on the temporary status?
That's a fantastic question. The trap, in our experience, is often a sense of comfort, or maybe even a bit of complacency,
Complacency. Okay.
People get secure in their H-1B, thinking they have years, maybe even 6 years, before they need to really worry about the green card. They might see it as something their employer will handle eventually.
Right, I'll cross that bridge later.
Exactly. But what they don't foresee is how a decade-long wait due to retrogression can impact promotions, maybe restrict job changes, or even just create this pervasive sense of being stuck and unable to plan major life events, like starting a family or buying a house.
Wow, yeah.
The true insight here isn't just to plan, but to understand that planning for a green card from day one involves actively documenting achievements, building a portfolio that could eventually qualify them for faster routes like EB-1, not just passively waiting for their employer to maybe file an EB-2 someday. It's about proactive self-advocacy, really.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
That perspective is crucial. It shifts the focus from just navigating the immediate immigration requirements to actively strategizing for the long term. So, okay, you've got your education, your experience, and your H-1B. You've successfully crossed that initial river. Now, the goal shifts to something more permanent, a green card.
Right. The ultimate goal.
But this journey isn't always smooth sailing, especially when we consider the different pathways available and the structural limitations within the system itself.
Indeed. If the H-1B is a bridge, then the employment-based or EB green card categories are that fertile land Chris M. Ingram mentioned.
Okay.
However, what we'll uncover is that not all land is equally accessible, and there are very specific reasons for that. There's a finite number of visas available each year, and the rules around how they're allocated are what create this complex landscape we're here to navigate today.
Finite number. That sounds like where the problems start.
Pretty much. To start, let's understand the broader picture of these employment-based green card preferences. There's an annual limit for all employment-based immigrant visas, which is approximately 140,000.
Okay, 140,000 per year globally.
Globally, yeah. However, it's worth noting that for fiscal year 2025, our team's research indicates this number has actually seen a slight increase to about 150,037. That's often due to various factors, like unused family-based visas from the previous fiscal year rolling over.
Ah, spillover. Got it.
Exactly. These visas are then allocated across different preference categories. They are split roughly equally, with EB1, EB2, and EB3 each receiving about 28.6% of the total available visas. That translates to around, say, 40,000, 43,000 visas per category.
Okay, so roughly equal slices for the main three.
Right. And the remaining percentages are then taken up by the EB4 and EB5 categories, which have their own specific purposes. This structured allocation is really the first layer of understanding why some paths move faster than others and why others become, well, bottlenecked.
So it's not a free-for-all. There are specific buckets, and each bucket has its own rules, criteria, and ultimately its own wait times. Let's dig deeper into the characteristics of each of these key EB categories.
Absolutely. First, we have EB1, or First Preference Priority Workers. This category is truly designed for the elite, the creme de la creme.
Okay, top tier.
Top tier. It's for individuals with extraordinary ability in the sciences, arts, education, business, or athletics, outstanding professors or researchers who are internationally recognized for their academic achievements, or multinational executives and managers being transferred to the U.S. from overseas operations.
Right.
The key advantage here, which is incredibly significant, is that no labor certification is typically needed.
No perm. That's huge.
Exactly. No perm process. This streamlines things considerably, making it much faster. But the requirements are stringent. You need evidence of sustained national or international acclaim, things like major awards, high-impact publications, leading roles, high salary, things that demonstrate you're really at the very top of your field. It truly is designed for top-tier talent who can prove their exceptional standing.
So if you're a Nobel laureate or maybe invented something world-changing, EB1 is probably your fast lane.
Pretty much, yeah.
But for many other highly qualified professionals, the next category, EB2, is a much more common route, which is where things often start to get really interesting and, well, complicated.
Precisely. Next, we have EB2, or Second Preference Advanced Degrees or Exceptional Ability. This category is for professionals holding advanced degrees, so a master's degree or higher, or a bachelor's degree plus 5 years of progressive post-baccalaureate experience in their field.
Okay, so advanced degree or equivalent experience.
Right. It also includes those with exceptional ability in the sciences, arts, or business, meaning they possess a degree of expertise significantly above that ordinarily encountered in their field. Now, for most EB2 applicants, it typically requires a job offer and that labor certification we mentioned, known as PER.
Right, the PER-M process.
Yeah.
Program Electronic Review Management.
That's the one. It's a Department of Labor step basically designed to ensure that hiring the foreign worker won't adversely affect U.S. workers, essentially, proving no qualified U.S. worker is available for the job.
Which can take time, right?
Oh yeah, PER-M can add significant time to the process. However, and this is a crucial exception, applicants can bypass that PER-M labor certification requirement with a National Interest Waiver, or NIW.
The NIW. Okay, tell us more about that.
This waiver is granted if it's demonstrated that the applicant's work is in the national interests of the United States. This could be things like developing critical technology, advancing public health, contributing significantly to economic growth, things like that.
So benefiting the U.S. as a whole.
Exactly. The NIW allows certain highly skilled individuals to self-petition, meaning they don't even need an employer sponsor, and they skip the often lengthy PER-M process. This makes it a powerful alternative for those who can really prove their work benefits the U.S. on a broader scale.
The NIW sounds like a fantastic alternative for those who qualify, cutting down a significant hurdle. For many listeners, though, national interest might feel a bit abstract. How does one actually demonstrate that their work meets such a high bar? What specific criteria are USCIS looking for when evaluating an NIW?
That's a really important question because national interest can indeed feel subjective. Our attorneys at the law offices of Chris M. Ingram focus on 3 key prongs established by a precedent decision called Matter of Dhanasar.
Okay, Dhanasar, what are the prongs?
First, the applicant's proposed endeavor must have both substantial merit and national importance. This means it's not just, say, a local project, but something that genuinely benefits the U.S. Broadly, think advancing a critical scientific field or developing a new medical treatment.
Okay, substantial merit, national importance, got it.
Second, the applicant must be well-positioned to advance this proposed endeavor. This involves demonstrating their education, skills, knowledge, track record. For example, a researcher with published papers and grants is clearly well-positioned to continue their research.
Makes sense. Credentials and ability.
Right. And finally, and this is crucial, on balance, it must be beneficial to the U.S. to waive the usual job offer and PER-M requirements. This means showing that the applicant's contributions are so valuable that requiring an employer and labor certification would actually harm the national interest by delaying or preventing that contribution.
So waiving the rules is actually better for the U.S. in this case.
Exactly. It's a holistic assessment of the impact and the unique qualifications of the individual.
That makes it much clearer. And finally, we have the EB3 category.
Indeed. EB3, or third preference, skilled workers, professionals, other workers. This is a broader category. It covers skilled workers who require at least 2 years of job experience or training, professionals who hold a U.S. bachelor's degree or its foreign equivalent, and a smaller subcategory for other workers, which typically refers to those performing unskilled labor requiring less than 2 years of experience.
So a wider range of jobs.
A wider range, yes. The key distinction here is that unlike some EB1 or EB2 NIW cases, this category always requires a labor certification, the PER-M process, to demonstrate that there are no qualified U.S. workers available. It's generally the most common path for bachelor's degree holders who don't have advanced degrees or clear exceptional abilities.
Okay, so PER-M is mandatory for EB3.
Got it.
So we have these different paths, each with its own criteria and complexities. But the reason we're even having this deep dive today is because of a single powerful constraint that impacts certain countries far more than others.
Exactly.
This brings us to the very root of our discussion, the per-country limit, which is the primary cause of retrogression.
This is where the intricacies of the system truly come into play and create the backlogs we're discussing. A critical statutory limit established in law states that no single country can receive more than 7% of the total preference immigrants annually.
7%. That sounds small. especially for big countries.
It is incredibly small when you consider population sizes. This means across all employment-based categories combined, a country is generally limited to roughly 9,800 to 10,500 visas per fiscal year.
Wow.
You might notice the Visa Bulletin specifically lists China, mainland-born India, Mexico, and the Philippines. These nations are designated because they have historically experienced, or are highly prone to, severe backlogs due to exceptionally higher demand for U.S. visas compared to that 7% cap.
Okay, so those countries are singled out because they always exceed the limit.
Pretty much. The all chargeability areas except those listed category then covers the rest of the world, where demand is typically lower. For those countries, visas tend to remain more readily available, and they avoid the dreaded backlogs almost entirely.
That 7% rule is incredibly impactful then.
They said my EB1 needed more categories. I can't even dock. What am I gonna do?
I need to find the right lawyer that can navigate me through this crisis. I need my EB1 so my new life can begin. These lawyers are amazing. They are walking me through every questions, making sure I don't miss a thing.
Thanks to the law offices of Chris M. Ingram, I'm cleared to land. But my career is gonna take off.
Houston. He got his visa.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
When you think about it, countries like India and China, each with populations well over 1 billion people, generate a disproportionately high number of incredibly qualified applicants, especially in STEM fields.
Absolutely. The talent pool is immense.
So this demand for U.S. green cards from these nations far exceeds their allotted 7% share. This massive imbalance creates what can only be described as severe chronic backlogs, stretching for years, even decades.
Decades, literally.
For smaller countries, or those with fewer applicants, they rarely hit this cap and thus avoid retrogression altogether. It's a striking disparity that truly highlights that traffic jam effect you mentioned earlier. And while unused visas from other countries can sometimes spill over to backlogged nations, it's important to understand that this spillover doesn't fully solve the persistent systemic delays for these high-demand countries, right?
Exactly. Spillover helps. It can move dates forward sometimes, but it's more like a temporary bandage, not a permanent solution to a deeply structural problem driven by that 7% cap versus the huge demand. And this brings us directly to India's EB2 predicament. Indian STEM workers, as we discussed, frequently qualify for the EB2 category due to their advanced degrees in fields like technology and engineering. For many, it's a natural and logical fit after their H-1B status.
Makes sense. Advanced degree EB2.
Right. However, because of the per-country limit, India's quota for EB2 is exhausted incredibly quickly each year. The consequence? Waits that can stretch beyond 10 years, sometimes, as our research shows, potentially decades. It creates immense uncertainty and frustration for highly skilled individuals who are already contributing so much to the U.S. economy. It's a situation that forces many to rethink their entire strategy.
This truly frames the dilemma and the opportunity, as attorney Chris M. Ingram so eloquently puts it. EB2 is a solid foundation, but for Indians, it's like planting a seed in crowded soil. EB1. That's fertile ground where your talents can bloom without the weight seize it if you qualify.
A great analogy, really captures the situation.
Expert. That's a vivid analogy. But while EB1 sounds like a clear solution, for many, extraordinary ability feels almost unattainable. Is it really a realistic option for most highly skilled Indian professionals? Or are we talking about a very small, elite percentage?
That's a crucial and common misconception, actually. While EB1 is certainly stringent, it's not just for Nobel laureates or Olympic athletes. Our team, Chris's team, has helped many professionals with strong, but perhaps not, world-famous profiles qualify for EB1A.
Okay, so it's broader than people think.
It can be. The key is understanding how USCIS defines extraordinary. It's often about consistent, significant contributions in your specific field, evidenced by things like publications, patents, a high salary compared to others, leadership roles, unique projects, maybe even media recognition about your work. These are things many professionals do have, but they might not realize these things count towards EB1 criteria.
So it's about documenting and presenting it correctly.
Exactly. So while it's not for everyone, It's a much more realistic path for a broader segment of highly skilled Indian professionals than they often initially believe. It's about how you present your case, how you frame your achievements within the legal requirements, not just about the raw achievements themselves.
That's a powerful distinction. It's about strategy, not just waiting.
Yeah.
Okay, so you now understand the different paths and the bottleneck that can arise due to these per-country limits. But how do you know where you actually stand in this complex system? How do you track your position in line and gauge how long your wait might be?
Right. How do you figure out your own situation?
Exactly. That's where the Visa Bulletin comes in, and understanding it is absolutely crucial for anyone navigating this process.
The famous Visa Bulletin.
Yes. Okay, so we've established the different green card categories and the bottleneck caused by the per-country limits. Now, let's talk about arguably the most important document you need to understand if you're navigating this process, the Visa Bulletin.
Your monthly immigration compass, you could say.
I like that. Your monthly immigration weather forecast, telling you whether it's clear sailing, a slow drizzle, or a prolonged storm of waiting. So what is the Visa Bulletin? It's a monthly report published by the U.S. Department of State. Its primary purpose is simply to show the availability of immigrant visas for the upcoming month.
Basically, who gets to move forward next month?
Exactly. It's the official guide that tells you when you can expect to potentially finalize your green card application. And it contains 2 key dates that are absolutely essential to understand.
2 charts, 2 dates, very important.
First, the final action dates. These are the dates when you can actually receive your green card or immigrant visa. For your application to be finalized and for you to be issued your green card, your priority date, which is essentially the filing date of your I-140 immigrant petition, or, if applicable, your PRM labor certification, must be current, meaning it's on or before this specific date listed in the bulletin for your category and country.
So if your priority date is earlier than the final action date, you're good to go for final approval.
Pretty much, yes. This is the date that dictates when your waiting period is truly over. Second, the dates for filing. Now, these are typically earlier dates than the final action dates. They indicate when you can submit your adjustment of status application, the Form I-485, even if your final green card isn't immediately available based on the final action date.
Ah, so you can file your paperwork sooner.
Exactly. And this is a significant advantage because filing the I-485 allows you to get in line and, crucially, often enables you to apply for and receive work and travel authorization, an EAD card, and advance parole much sooner. This provides a bit more stability and flexibility while you wait for your priority date to become current under the final action dates.
That's a big deal, getting the work permit while you wait.
Huge deal. You can always find this vital document on the official U.S. Department of State website, travel.state.gov, usually under the Visa Bulletin section. It's a public resource, and checking it regularly, like monthly, should become a habit for every applicant.
Understanding the distinction between these 2 dates is absolutely fundamental. The dates for filing chart, when USCIS decides to use it, often gives applicants a psychological and practical boost, right? Allowing them to gain employment authorization and travel documents can alleviate some of the stress of the long wait and provide more freedom.
Definitely reduces the anxiety.
It does. But it's important not to confuse this with having the green card in hand. The final action dates chart is the ultimate determinant of when the permanent residency process actually concludes. Our attorneys emphasize that both dates serve different yet equally important purposes for the applicant's journey.
Right. It's like being able to get on the highway, get your EAD, even if the final exit ramp, the green card, isn't open yet. Now, let's talk about how to read the charts themselves, and we'll use some real-world examples from our team's recent legal research to make this clearer.
Okay, let's look at some dates.
The bulletin itself has a very specific structure. It includes detailed charts for both family-based and employment-based categories, and crucially, it's broken down by country. This country-specific breakdown is where the impact of the per-country limit becomes, well, painfully visible and deeply personal for many.
Yeah, you see those specific countries listed out.
Exactly. Let's look at an example from our legal research. EB2 India, as of September 2025, the final action date listed is January 1st, 2013.
January 2013, wow.
Yeah. Now, if your priority date is after January 1st, 2013, it means you are still waiting for your turn. You're still in line, and your green card cannot be finalized yet. You literally cannot even apply for your final green card using the final action chart because the quota for your country and category has been exhausted up to that date.
So anyone who filed after early 2013 is still waiting in late 2025. That's over 12 years.
Over 12 years. Now compare that to another example, EB2 China, also as of September 2025. Here, the final action date is December 15, 2020.
Okay, 2020. Still a wait, but much better than 2013.
Much better. You can immediately see how this differs significantly from India's date. China also faces retrogression in this category, but for that specific category, the wait is notably shorter than for India, at least in this snapshot. This highlights the varying pressure on different countries. And then let's consider EB1 India as of September 2025. The final action date here is February 15th, 2022.
February 2022. Okay, that's much more recent.
Much more recent than the EB2 India date of 2013. This indicates a significantly shorter wait time for EB1 applicants from India, still technically retrogressed compared to being current, but vastly better than EB2. This striking difference between EB1 and EB2 dates for the same country is precisely why strategic shifts are so important.
These comparative examples are incredibly illuminating, aren't they? They demonstrate the tangible effect of the per-country limits and the varying demand. For you, the listener, seeing these dates side by side should immediately highlight that simply qualifying for an EB category isn't enough. Your country of chargeability and the specific category you apply for profoundly influence your wait time. It underscores why a strategic assessment, like the one our attorneys conduct, is so vital to understand your true position and potential options.
Absolutely. And once you understand those dates, you can start estimating your wait times and truly understanding retrogression in action. To approximate your wait, you perform a simple calculation. Subtract the final action date from the current date.
Rough math, but gives you an idea.
Exactly. So, using our example for a new Indian EB2 applicant with a final action date of January 2013 and September 2025, the backlog is roughly 12 years. 2025 minus 2013. That's a significant amount of time to be waiting.
12 years is a huge chunk of someone's life.
It really is. For China EB2 at December 2020, it's about 5 years, 2025 minus 2020. Still long, but less than half the wait for India in that same category at that time.
Rome, 20,000 spectators, one epic battle, 2 warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
Off to the Lions pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
However, it's really important to add some critical caveats here. These are strictly approximations. The dates can advance at varying speeds, sometimes about 1 year per fiscal year, maybe a bit more with spillover, but this is by no means guaranteed.
We're not guaranteed at all. Dates can stall or even go backward.
Exactly. Our team has seen them jump by several years or sometimes barely move at all for months on end. Factors like increased demand for visas in a particular category or country, the availability of those spillover visas from underused categories, or even policy changes can cause these dates to fluctuate, sometimes dramatically. They can advance quickly or, regrettably, move backward.
And that backward movement, that's retrogression.
Precisely. Which brings us to the exact definition of what is retrogression. It's not just a fancy term. Retrogression is when demand for visas in a specific category and country exceeds the available supply for the upcoming month or quarter, causing the final action dates to actually move backward in the Visa Bulletin compared to the previous month.
So a date that was maybe February 1st last month could become January 1st this month. You actually lose ground.
Exactly. You lose ground. For example, our legal research notes that in August 2025, EB2 worldwide retrogressed due to high usage across the board. This means that a date that was current 1 month could suddenly find itself in a backlog the next, creating a frustrating moving target for applicants. This is precisely why checking the bulletin monthly is crucial for tracking your position in line and understanding the true weather forecast of your immigration journey.
Chris M. Ingram's analogy here is spot on. He says, the Visa Bulletin isn't just numbers, it's your timeline to freedom. Read it like a weather forecast. It tells you when the storm of waiting might clear.
I like that. Timeline to freedom.
It really drives home the personal impact of these dates, doesn't it? It's not an abstract concept. It directly translates to years of waiting, often impacting significant life decisions about careers, family, buying a home. The monthly check isn't just bureaucratic. It's a vital tool for personal and professional planning.
That's a powerful way to put it. It turns abstract dates into a very real measure of anticipation and, unfortunately, often uncertainty.
Yeah.
Now that you know how to read your immigration compass, let's talk about why the forecast for some looks so much more challenging than for others, particularly those Indian EB-2 applicants.
Yeah, let's dig into that specific situation. If the Visa Bulletin is the weather forecast, then for Indian EB-2 applicants, it often predicts a prolonged storm, one that, as we saw, can stretch for over a decade. This section delves into the specific structural reasons why retrogression is such a significant and persistent hurdle for this particular group, causing immense stress and really requiring strategic navigation.
Okay, so why them specifically?
At its core, retrogression is fundamentally a supply and demand problem, much like, a severe traffic jam on a major highway during rush hour.
Good analogy.
You have too many qualified applicants from a single country, think of them as cars, all trying to get on the same road, and not enough available visas or lanes open on that highway due to that 7% per country limit. This issue becomes particularly acute for Indian EB-2 applicants. The per-country cap of 7% of total employment-based visas simply doesn't scale with the immense continuous demand from India. To put it into perspective, while applicants from many other countries might face only months of waiting for their green card in EB-2, Indians often face years, sometimes even decades, due to this chronic oversubscription.
And the question naturally arises, why India specifically? I mean, we touched on it, but let's reiterate.
Well, our team's research highlights that India's exceptionally high education levels and the sheer prevalence of STEM professionals mean a vast, highly qualified number of individuals enter the U.S. workforce eeach year through F1, OPT, H-1B.
Right, the pipeline is huge.
Exactly. This perfectly matches the U.S. demand for these critical skills in tech, engineering, and medicine, yet it simultaneously creates an overwhelming queue under the current cap system. The sheer volume of highly skilled individuals means that the 7% cap for India is quickly reached and then massively exceeded year after year. It's really a testament to their talent, but also exposes a structural flaw in the system for this particular demographic.
It's like trying to fit an elephant through a keyhole.
That's a pretty good way to put it, yeah. The consequence of this disparity is stark. A priority date from, say, early 2013 might only become current in late 2025, leading to incredibly long waits that essentially freeze an individual's path to permanent residency for over a decade. And this isn't just a number, it represents a significant portion of an individual's career in life, often impacting major personal milestones. I remember hearing a story once from our team about a couple who literally put off having children for years because of their priority date uncertainty. It's not just paperwork, is it?
No, it's absolutely not. That story really brings home the profound human impact of these policies. It affects real lives in deep ways. And living under this cloud of retrogression, it must create immense pressure.
Immense pressure.
Many Indian EB-2 applicants facing these long backlogs are forced to extend their H-1B status beyond the usual 6-year limit, often utilizing provisions like AC-21, right? The American Competitiveness in the 21st Century Act.
That's correct. AC-21 allows them to extend their H-1B in 1 year or sometimes 3-year increments if their green card application, specifically the I-140, is approved, but they're stuck waiting for their priority date to become current. It's a lifeline, but it's still temporary status.
Right, a lifeline. But the downside of this is substantial. This prolonged reliance on temporary visas creates immense stress and precarity. Imagine the impact. A job loss could mean having to leave the U.S. entirely, despite years of contribution, years of paying taxes, and a pending green card application just waiting for a date.
It's a constant fear for many.
It profoundly impacts family planning, limits career mobility, because changing jobs can be risky or complicated with a pending green card, and introduces overall instability that affects every aspect of life. It makes long-term planning incredibly difficult and often feels like your life is just on hold indefinitely.
This is precisely where a strategic shift becomes not just beneficial, but absolutely essential for many. Leveraging EB-1 becomes the opportunity many need to break free from that holding pattern.
Okay, so shifting strategy to EB-1.
Yes. Our team helps clients by conducting a thorough assessment to see if they might qualify for the EB1 category. As we discussed, EB1 typically has significantly shorter waits, even for applicants from India, precisely because fewer individuals meet its stringent criteria, and thus the 7% cap for EB1 India is not as quickly exhausted as it is for EB2 India.
Makes sense. Fewer people qualify, shorter line.
Basically, yes. And the crucial mechanism here, and one our attorneys frequently employ with great success, is priority date porting.
Priority date porting. Okay, explain that again.
If an EB1 petition is approved for an applicant who previously filed an EB2 petition and had that I-140 approved, they can port or transfer their earlier EB2 priority date to the new EB1 application.
So they keep their original spot in line.
Exactly. This is a game changer because it allows you to retain your original place in line, the date your green card journey officially began, while simultaneously accessing EB1's typically faster queue. The key condition is that your ported EB2 priority date must be prior to the current EB1 cutoff date for your country of birth, as shown in the Visa Bulletin's final action chart. This strategy effectively allows you to bypass years, sometimes over a decade, of EB2 retrogression.
That's a fantastic analogy from Chris M. Ingram's team. Picture it. The EB2 line is a slow train. EB1 is express. Porting lets you switch trains without losing the time you already invested waiting at the station. It perfectly illustrates how you can move from a decades-long wait to a potentially much shorter one simply by making a strategic category shift.
It absolutely does, and this leads directly to attorney Chris M. Ingram's powerful empowerment message. Retrogression tests your patience, but it's not unbeatable. With EB1 porting, you're not just waiting, you're strategizing. Take control today.
Take control today. I like that.
This message is so important because it shifts the listener's perspective from feeling like, a victim of an uncontrollable system to becoming an empowered agent actively seeking and implementing solutions. It highlights that there is agency in this process, and expert guidance can unlock those solutions that others might miss or even dismiss.
Theory is one thing, but let's look at how these rules and strategies play out in real life. Our team has several compelling case studies from their legal research that perfectly illustrate these points, offering concrete examples of how individuals have navigated these complex paths and found their breakthrough.
Yeah, let's look at some real stories. It makes it much clearer.
Understanding the rules and the dynamics of retrogression is vital, but seeing how they apply to real people makes all the difference. Our legal team has shared 3 compelling case studies that illustrate different experiences with EB2, EB1, and crucially, how to overcome the challenges of retrogression. These aren't just anecdotes, they're powerful lessons that show what's possible.
Okay, let's hear them.
Let's start with Emily Hargrove, a British engineer's EB2 journey. She offers a perspective that many from high-demand countries might envy. Emily is a 35-year-old British-born mechanical engineer specializing in renewable energy. Her journey began with an F1 visa back in 2015, which brought her to the U.S. to pursue her master's in engineering at MIT.
Good start. MIT.
Yeah. During her studies, she gained valuable experience through pre-completion OPT, interning at a Boston tech firm, and honing her skills in wind turbine design. After graduating in 2017, Emily secured full-time employment via post-completion OPT. She was fortunate that her STEM background allowed her to extend her OPT for an additional 24 months, bridging her into an H-1B visa in 2020. Her employer sponsored her for a specialty role developing sustainable technology.
So F1 to OPT to H-1B. Classic path.
Classic path. And the H-1B process was fairly straightforward for her. With an advanced degree, she qualified for the master's cap and didn't face the intense lottery woes that many others do. By 2021, with her career thriving, Emily's employer filed for her EB2 green card. As a professional with an advanced degree, she fit perfectly. The program took about 6 months, followed by the I-140 approval. Her priority date, March 2021.
Okay, March 2021 priority date.
USCIS is cracking down on visa fraud, and even approved cases are being revoked.
Why was my visa denied? USCIS revoked my approval. At the law offices of Chris M. Ingram, we handle every detail with care. Every form, every fact, every time.
So join us for a free consultation. We do things the right way. Let us take care of you.
Now, here's the key difference for Emily. As a rest-of-world applicant, meaning she was from the UK, the Visa Bulletin showed no significant backlog for EB2, for her country. The demand from the UK, Chris M. Ingram's reflection encapsulates this perfectly. Emily's path shows immigration at its best, efficient and rewarding. If your journey feels stalled, remember, options exist to accelerate. This contrast really sets the stage for the next, more challenging but ultimately triumphant case.
Emily's case is the ideal scenario, the system working as intended when demand aligns with supply within those limits. Our team sees these cases, and while we celebrate them, they serve as a stark reminder of the unique challenges faced by applicants from countries like India or China. This makes the strategies we're about to discuss even more critical.
Indeed. Now, for a scenario that many of our listeners will find much more relatable, we turn to Raj Patel, an Indian software developer's EB-1 triumph. Raj truly embodies the classic STEM immigrant struggle in the U.S. and ultimately a significant victory.
Okay, Raj's story. Let's hear it.
Raj, a 32-year-old Indian software developer from Mumbai, came here in 2016 on an F1 for a master's in computer science at Stanford. He used OPT in 2018, then STEM OPT, building a reputation for developing innovative AI algorithms.
Stanford Comp Sci, strong background.
Very strong. In 2020, Raj successfully won the H-1B lottery, transitioning to a senior developer role at a prominent fintech company. His AI expertise quickly made him indispensable. By 2021, his employer sponsored him for an EB-2 green card. PRM certified, I-140 approved, priority date established as June 2021.
June 2021. So right into that massive EB-2 India backlog we talked about.
Exactly. The Visa Bulletin delivered the harsh truth. EB-2 India final action date stuck around 2012-2013. For Raj, despite his qualifications, retrogression presented him with that daunting 10-plus year wait. He was forced into H-1B extensions, living with constant anxiety, family plans delayed, career moves risky, the whole 9 yards.
The exact situation we described earlier, the stress must have been immense.
Immense, and the challenge for Raj was compounded by legal advice he got elsewhere. Other lawyers, unfortunately, dismissed his chances for an EB-1 visa, telling him he simply wasn't extraordinary enough by their standard.
That's discouraging, and happens too often, unfortunately.
It was discouraging. Raj felt stuck. But then Raj found the law offices of Chris M. Ingram. Our legal team, with our dedicated researchers, reviewed his comprehensive portfolio and saw potential where others did not. We identified several key achievements aligning with EB-1A criteria, multiple patents in machine learning, high-impact publications in top journals that were widely cited, leadership roles in influential open-source projects impacting millions, a significantly high salary relative to his peers, and even features in tech media about his innovations.
So digging deeper revealed the EB-1 potential.
Exactly. Based on this, our attorneys meticulously built a compelling EB-1A case for extraordinary ability. We gathered strong testimonial letters from industry leaders, compiled detailed evidence of his high salary, highlighted the media features, proving his national and international acclaim. The EB-1A petition was filed in 2024 and, to Raj's immense relief, approved in months.
Fantastic news for Raj.
Fantastic. And here's the strategy that made all the difference, and it's a critical lesson for you, the listener. With EB-1 India having a final action date of February 15th, 2022 at that time, our legal team was able to port his earlier EB-2 priority date of June 2021.
Porting the date, okay.
Since his ported date of June 2021 was prior to the EB-1 cutoff date for India, February 15th, 2022, Raj immediately became current. He effectively jumped ahead in line, bypassing years of EB-2 retrogression, turning a decade-long wait into a matter of months.
That's the power of porting combined with EB-1 approval. Amazing.
The outcome was transformative. His I-485 was approved swiftly, green card issued by early 2025. Raj is now free to innovate without constraint. He has since started his own AI venture, unleashing his full potential.
Wow. From stuck in Backlog to starting his own company. That's incredible.
Incredible.
Yeah.
The lesson from Raj's story is so powerful. This case proves that with the right strategy and expert legal counsel, retrogression for Indian EB-2 applicants is surmountable, even when initially dismissed by others. Attorney Chris M. Ingram's call to action echoes this. Raj's story is a call to action. Don't accept delays as destiny. Your talents deserve recognition. Let's showcase them and unlock your future now.
Raj's case is a prime example of proactive lawyering. It highlights that self-doubt or even initial negative assessment shouldn't be the final word. Our attorneys are trained to look beyond the surface, identifying those extraordinary achievements that, when properly documented and presented, can meet the stringent EB-1 criteria, and that priority date porting. It's a crucial mechanism that turns eligibility into a tangible, accelerated path, a genuine breakthrough.
It really is. It's about recognizing and then championing an individual's unique contributions. Now, for our third case, let's look at a slightly different yet equally impactful path. Dr. Priya Singh, an India researcher's direct EB1 path.
Okay, Dr. Singh, a researcher this time.
Yes. Dr. Priya Singh is a 38-year-old Indian biochemist from Delhi, PhD in molecular biology from UC Berkeley in 2014 on an F1 visa. Used OPT for postdoc research in 2019, then STEM OPT, focusing on cancer drug development.
Important field, cancer research.
Very. She secured an H-1B in 2021 at a leading pharmaceutical lab, where her groundbreaking work on gene editing quickly earned significant acclaim within the scientific community. Her employer sponsored her for an EB2 green card in 2021, priority date April 2021.
April 2021. So, again, facing that long EB2 India wait.
Exactly. Visa Bulletin showed EB2 India stuck around 2013, another potentially endless queue. But the crucial difference for Priya was her inherent EB1 potential right from the start. She had the credentials for the outstanding researcher category. Her resume boasted over 50 citations of her work in peer-reviewed journals, significant NIH grants she'd secured, numerous invited lectures at international conferences, and consistently strong peer reviews.
Sounds like a strong EB1B case already.
It did. However, initial self-doubt and maybe a lack of focused legal guidance initially held her back from pursuing EB1 directly. She just didn't quite see herself as extraordinary enough, or maybe didn't realize EB1B was such a viable option.
Common feeling, unfortunately. Imposter syndrome is real, even for brilliant researchers.
Absolutely. It wasn't until 2024, when Priya contacted our legal team, that her path shifted dramatically. Our attorneys reviewed her extensive achievements and immediately advised a direct EB1B filing. That's the outstanding professor-researcher category, employer-sponsored. Our team meticulously compiled a robust dossier, research impact, peer recognition, contributions to cancer drug development.
Building the case for outstanding researcher.
Exactly. The strategy was highly effective. The EB1B petition was approved rapidly, which is a common advantage, as EB1B avoids the time-consuming PRM process.
Right, no PRM for EB1B.
Just like Raj, porting her earlier EB2 priority date of April 2021 was absolutely key. Since this date was well before EB1 India's February 15, 2022 cutoff date at that time, Priya's application instantly became current.
Again, the porting makes her current immediately upon EB1 approval.
Immediately. The outcome was remarkable. Green card arrived by late 2025. Today, Dr. Priya Singh heads her own lab, continuing her pioneering work patenting novel therapies. She transformed her career uncertainty into a leadership role.
Another fantastic outcome, leading her own lab.
Fantastic. The lesson from Priya's journey is clear. Academics and researchers with significant achievements should recognize their potential and can often bypass EB2 pitfalls entirely by proactively pursuing EB1 directly. It shows that a well-informed, proactive strategy can lead to a significantly quicker path. Chris M. Ingram's reinforcement resonates strongly here. Priya reminds us, knowledge is power, but action amplifies it. If retrogression looms, explore EB1, your breakthrough awaits.
Priya's story underscores a critical point. Identifying EB1 eligibility isn't always straightforward for the individual themselves. Many talented professionals, despite extraordinary achievements, might not recognize how they fit the specific criteria, or they might feel modest. This is where the expertise of our attorneys comes in. We have the experience to meticulously review qualifications and build that robust case, transforming perceived long waits into expedited journeys. It's about knowing precisely how to articulate and document achievements within the precise framework of immigration law.
These stories aren't just anecdotes, they're powerful proof that there are viable pathways forward. Even when the default route seems interminably long, they offer real hope, don't they?
They really do. Hope and actionable strategy.
So what does this all mean for you, the listener, and what actionable steps can you take if you find yourself in a similar situation?
Yeah, let's summarize the takeaways. We've covered the nuances of the system, the quotas, the Visa Bulletin, and heard these compelling stories of success. If there's one key takeaway for you, especially if you're an Indian EB2 client or facing a similar long wait, it's this. Retrogression is not the end of your American dream. There is a faster lane, and our attorneys are here to help you find it.
The faster lane. EB1.
Primarily, yes, the EB1 advantage. As we've seen through Raj and Priya, EB1 offers a significantly shorter wait time for green card approval, even for applicants from India, compared to the heavily retrogressed EB2 category. This acceleration can mean years, sometimes over a decade, shaved off your waiting period. That allows you to establish your permanent life here much sooner.
And the key mechanism.
And central to this advantage is priority date porting. This crucial mechanism preserves your earlier investment of time and effort. It allows you to transfer your original, earlier EB2 priority date to a newly approved EB1 petition. This effectively lets you jump ahead in line, provided that your earlier priority date is indeed prior to the current EB1 cutoff date for your country of birth. It's a completely legal and powerful strategic move that directly addresses the backlog problem by shifting you to a less congested category.
So it's not just about qualifying for EB1, but strategically using your existing priority date to your advantage. It's like having an old ticket for a crowded bus and then getting a VIP pass for the express train, but still being able to use your original boarding time.
That's a great way to think about it, yes.
That's powerful. Now let's talk about some concrete actionable steps for our listeners.
Okay, practical steps.
First, and perhaps most fundamentally, know your priority date. This date is your place in line, your timestamp in the queue. It's the single most important piece of information. If you don't know it, find it on your I-140 approval notice or maybe your PRM certification documents.
Absolutely critical first step. Know your date.
Second, check the Visa Bulletin regularly. Make it a habit. Set a monthly reminder. This is your weather forecast. It keeps you informed about the final action dates for your category and country, helping you understand if the wait is changing. Staying informed empowers you to make timely decisions.
Can't strategize if you don't know the current situation.
Exactly. Third, and perhaps the most critical if you're facing retrogression, critically assess your EB1 eligibility. Don't just assume you don't qualify, especially if others have maybe told you that in the past without a deep dive. Take a fresh, objective look at your achievements.
Be honest with yourself and thorough.
Right. Do you have extraordinary ability? Consider patents, publications, major awards, high salary, leadership roles, media features, significant impact. If you're an outstanding professor or researcher, look at citations, grants, invited lectures, peer reviews. Gather all that documentation, even if you're not sure it counts.
Document everything. You might be surprised what qualifies. Even with a master's degree, if your career strides are significant, EB1A could still be an option. Don't rule it out based just on degree level.
Good point. And this leads directly to the final and arguably most important actionable step.
Which is?
Seek expert counsel. As Raj and Priya's stories show so vividly, a thorough review by experienced attorneys, like our team at the law offices of Chris M. Ingram, can uncover eligibility for EB1 that you or even other general practitioners might have overlooked.
Specialized knowledge makes a difference.
It really does. We know precisely what USCIS is looking for in EB1 petitions, how to gather and present your evidence most effectively, and how to build that robust case that maximizes your chances of success. It's about translating your real-world achievements into the specific language and evidence requirements of immigration law.
Absolutely. It's about framing your story correctly for the adjudicator.
It's about getting that expert opinion that could dramatically alter your timeline and your future.
Precisely. And that's why we extend an invitation for consultation. At the law offices of Chris M. Ingram, our legal team has a strong track record of turning what initially seemed like long, disheartening waits into significant wins for our clients. We have the expertise to help you navigate these complex waters and identify the best path forward for you.
How can people reach out?
You can visit www.breakthroughusa.com for a free consultation. This is your opportunity to speak with our attorneys, assess your unique situation based on your profile, and explore if EB1 is a viable path for you. As attorney Chris M. Ingram consistently encourages, immigration is a marathon, but with smart pivots, you can sprint to the finish. Don't wait, act, and make America your permanent home.
Sprint to the finish. I like that too.
It's a philosophy of empowerment that has guided countless individuals to achieve their green card dreams, and it can guide yours too.
So what does this all mean for you, the listener, as you consider your own journey and the path ahead?
This really raises an important question, doesn't it? If you're facing a long wait, are you actively exploring every possible avenue to accelerate your path? Are you documenting your achievements, seeking specialized advice, or are you perhaps passively accepting the status quo, just hoping for the best?
That's the challenge. Remember the words of attorney Chris M. Ingram. Every delay is an opportunity in disguise. Seize the day, qualify for EB1, and transform your American dream into reality. What will your next step be in seizing that opportunity and taking control of your immigration future? Thank you so much for being with us today. We hope you gained a lot for this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram. where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this legal research for our presentation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughUSA.com and schedule an appointment. We'd love to hear from you and help you if we can. See you next time on Let's Talk U.S. Immigration. Bye for now.